Hello and welcome to this webinar looking at issues to be considered as part of end-of-life care planning. It's clearly a sensitive issue and the practitioner needs to be aware of relevant and being able to give correct legal advice in order to meet the client's needs and wishes, but also strive to do that with empathy and care. And for me, the main priority is giving the client peace of mind. So when considering end-of-life matters, it's necessary to consider a broad range of issues, including vulnerability, testamentary provisions, trusteeships, powers of attorney, in particular health and welfare powers of attorney, advance decisions, advance statements, organ and body donation, provision and funding of care, including NHS continuing healthcare, and particular issues where the client may lack capacity. We'll only be considering some of these issues today, but it's important to take an holistic approach when dealing with end-of-life care planning. So today's aims are to consider the meaning of personal welfare, the character and creation of health and welfare lasting power of attorney, attorneys, so who can act, choices and duties, instructions and preferences, giving or refusing consent to life-sustaining treatment, interaction with advance decisions to refuse treatment, revocation of health and welfare lasting powers of attorney, and decision-making in the absence of a health and welfare lasting power of attorney. So firstly, I'm going to look at the regulatory framework. There are mandatory principles which apply to all professionals regulated by the SRA, and failure to meet those professional duties may result in SRA sanctions or referral to the Solicitor's Disciplinary Tribunal. And failure to meet the needs of a vulnerable client could put you at risk of a discrimination claim or a claim for a failure to make reasonable adjustments under the Equality Act, a claim for damages or compensation against you or your firm if you act on the instruction of a client who lacks capacity, or instructions of somebody who doesn't have authority to give those instructions. A complaint made against you to the legal ombudsman, which could result in your name being published and or you having to pay financial compensation, complaint to the SRA, or reputational risk. Legal practitioners must be satisfied that their client has capacity to give proper instructions, and that obligation is supported by case law. Let's see, for example, RP and Nottingham City Council. It's also supported by the SRA's Code of Conduct for Solicitors, including Rule 3.4, which specifically requires solicitors to take account of your client's attributes, needs and circumstances, and Rule 3.1, which states that you only act for clients on instructions from the client or from someone properly authorised to provide instructions on their behalf.